San Diego. Thank you so much for joining this program. We have what I feel is really exciting. It touches about all of my practice areas, the wonderful world of AI, antitrust, AI watching, and greenwashing. Oh my. And we want to present or introduce you to our speakers today. So we have Gretchen Jankowski, a shareholder and the litigation co-chair at Buchanan, Ingersoll, and Rooney, as well as another seasoned litigator, Jennifer Oliver. Both of them have extensive experience litigating in federal court. Gretchen has been doing it for 30 years, and Jennifer has a really wide practice that includes data privacy, cybersecurity, and also some advice and counsel. So without further ado, I'm going to turn it over to our speakers to launch us into today's CLE.
Thank you, Alexa. It's a pleasure to be here. I'm sure I speak for Gretchen as well when I say we're equally excited about this topic and the opportunity to talk to you all about this ever-changing and evolving area of law. So a minute about our agenda today. We're going to get started talking about AI and antitrust and the intersection there, and some interesting developments in that area at the regulator level, as well as some private litigation that we're seeing. We're going to talk a little bit about AI washing, and if you're not familiar with that term, no worries, we will explain what it is. But another new trend that we're seeing in the AI area, AI and greenwashing, which is a little bit different than AI washing, but has some intersection there as well. In another area, we're seeing some new litigation pop up. And then finally, we get to the good part. Of course, we have to keep you here until the end when we talk about how you and your clients and companies can mitigate your risks surrounding AI. So without further ado, I will turn it over to Gretchen, and she's going to talk a little bit about AI and antitrust.
Thanks, Jen. And for those of you that saw the cover slide, obviously there was a picture that you likely recognized of the Emerald City, but in keeping with our theme, it is not a picture that we just grabbed off the internet. We used an AI image generator to basically create that cover image for Emerald City. That won't be the only image that you see today that was generated with AI. So we're going to start, and I'm going to talk at least initially about what is generative AI. As you can see on the screen, it is something that many of us are completely familiar with, at least from news articles. ChatGPT is the one that we're most familiar with. It's the one that is most popularized. But generative AI can be used to create new content, audios, code, images, text, videos, all kinds of things. And the distinction here is that it can be trained to learn human programming language, art or chemistry, biology, anything that is a complex subject matter. With respect to generative AI, I thought it was sort of important to cover, because we're speaking obviously to in-house lawyers and outside lawyers today, as to how are lawyers presently using generative AI. There are studies that are published. There are news articles that are published out there. Of course, this is a subject matter that changes every day. And I think many of us are, to some degree, tired of seeing it in the news, because there isn't a day that goes by that there aren't multiple articles on AI in some form. But at least the literature that's out there is saying most lawyers, in-house and outside lawyers, are using AI in like 5 main arenas: to draft marketing materials or attorney bios, to summarize documents, and generate transcripts from meetings. Many of you may have stumbled upon that in one of your platforms that you use, whether it's Teams or another platform. And we won't talk about the privilege concerns associated with that, but that is something that many of us have stumbled upon and not even realized it was occurring. Drafting legal material, and we're all familiar with the very famous case of the lawyer in New York that used generative AI to draft a brief with fake citations. But I know there are lawyers, Jennifer and myself included, that are using it in an appropriate way, as well as doing legal research. Those are the primary areas. And then the last area, of course, is what I'll call e-discovery and review platforms. A lot of review platforms that lawyers are using have generative AI as a component of it. And now you're starting to see press releases from various law firms, our law firm included, about internal generative AI platforms that are proprietary to law firms. If you don't know what I'm talking about, you can run a quick Google search while you're on this webinar and type in Buchanan and artifacts, and you will see that we have press releases on the internal AI platform that we use in-house, that is proprietary to us and can only be accessed by our lawyers. But that should give you a sort of a flavor for generative AI. Then let's talk a little bit about the antitrust implications for generative AI and risks in the market. There obviously are numerous competition risks when we start talking about generative AI. But before I explain some of the risks, let me just outline very briefly at a very high level for those of you that are on this call that maybe are not antitrust practitioners or don't really deal with antitrust areas very often. You have Section 2 of the Sherman Act makes it unlawful for any person, and that means any company as well, to monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of trade or commerce among the several states or with foreign nations. Section 2 of the Sherman Act is primarily focused on unilateral conduct. What does a company do to attain or, as is often the case, keep monopoly power? And if you think about the types of unilateral conduct that are the subject of enforcement actions or private litigation, there's a lot of conduct that federal and state enforcers are potentially concerned about when they're talking about generative AI in particular. And that type of conduct is exclusionary product designs, exclusive dealing arrangements, predatory pricing for generative AI products, refusals to deal with competitors, refusals to share essential facilities such as data, hardware, software with competitors, or bundling and tying of services. And bundling occurs when a business offers multiple products in a single package, and tying occurs when the sale of one product is conditioned on the sale of another product. The agencies, and when I say agencies, I'm really talking about the DOJ and the FTC primarily when you're in this space. The agencies are really concerned that businesses may be able to link new generative AI products with existing core products to potentially reduce the value of a competitor's standalone AI offering. Section 7 of the Clayton Act specifically addresses practices that the Sherman Act does not clearly prohibit. Section 7 prohibits mergers and acquisitions where the effect may be to substantially lessen competition or tend to create a monopoly. And so some of the areas where the FTC and DOJ are focused are large firms buying nascent competitors, and that has been a recent focus of the FTC, specifically with respect to generative AI. They've identified, the FTC has certainly identified a number of potential antitrust risks for generative AI, and data is one of the major concerns, because it's the key input really for training and developing AI models. And the FTC views data as a potential barrier for some companies, since larger existing companies that we are very much familiar with may have access to more data on their own. and new players may be kept out of the market. It's also an even bigger issue when you start talking about particular sectors, such as highly regulated industries, such as healthcare and financial services. Those are two industries where generative AI is being used. If you look at any healthcare company these days, you're going to see press releases where healthcare companies, in some ways, are using the same provider to share data and generate use generative AI to improve the dissemination of healthcare to consumers. And we're going to talk a little bit about those risks, because I think a lot of what is happening in some of these industries is the technological people are getting far out in front of this and not consulting lawyers. And some of you on this phone may be keenly aware of that. Another key input into developing generative AI models is, the computing resources themselves, hardware, software, but both physical and virtual. And that really becomes important, because the FTC has stressed that cloud computing already is a concentrated industry. And it's one that we know that the FTC is paying attention to. The FTC has also flagged potential competition concerns related to open source models. Open source models, and you've certainly seen open source models being discussed in the news as well, do offer great potential, as users can build on them and create innovative new developments, but they can outpace the original model in terms of innovation and utility. And there is a concern that companies that offer open source models will then lock their users in. And that becomes an antitrust concern for both the FTC and the DOJ. The other thing that is important to realize is that, the FTC, while in a lot of respects, when you think of the FTC, you're not thinking of the Sherman Act, because the FTC really is dealing with unfair methods of competition, unfair or deceptive acts or practices. But the Supreme Court has said that all violations of the Sherman Act also violate the FTC Act. So although the FTC does not technically enforce the Sherman Act, it can bring cases under the FTC Act for the same kinds of activities that you would see the DOJ bringing. So I want to now turn to pricing algorithms, because that's really a separate area when we're talking about AI. This is one of those areas that most of you are already familiar with. If you shop on Amazon, as many of us do, you already know that an algorithm rather than a human probably set the price of the item or the service that you're buying. If you've used any ride sharing platform, whether that's Uber or Lyft, you already know that algorithms are being used for that. Within an 8-hour period, because you've seen it, that the price to go from point A to point B will change based on supply and demand. But pricing algorithms all the way around have truly become ubiquitous in online retail, because automated systems have grown, and a lot of companies are using them. And we're going to talk, and Jennifer's going to talk more specifically about what we're seeing in the enforcement and private litigation with respect to pricing algorithms. But this is not anything new. Pricing algorithms have been used by companies like airlines and hotels for a very long time to set their prices. Now, in terms of the competition risks, what really is implicated with pricing algorithms is Section 1 of the Sherman Act, which prohibits any contract combination in the form of trust or otherwise a conspiracy in restraint of trade. In essence, it prohibits price fixing. And that's really the antitrust risk that is associated with pricing algorithms. And again, this is not something new. A clear-cut case of pricing algorithms occurred in 2015. So obviously a while ago. This is not anything new. Now, what we're seeing in the cases is a little bit new. But in terms of how long this has been around, the DOJ criminally prosecuted online sellers who were using the same pricing algorithm to fix prices of posters that were sold online. And they were using this algorithm, and it essentially amounted to price fixing. And the DOJ basically said that it was the epitome of an antitrust violation, because the only variation was the parties were using algorithms, and in some ways not all that different than traditional price fixing when you think of competitors getting together in a room and discussing how, what price they're going to charge for something. But as the DOJ has repeatedly said, price fixing is per se illegal. But the real question, and this is one of the areas that we are definitely going to talk about, because there is definitely a difference in some of the cases that we're seeing, is to what extent does the pricing algorithm become an antitrust violation? Is it actual coordination or is it not? And so with that, what we do know with certainty is that if we look at what has happened and recognize it's June, but we're halfway through 2024, but what we are seeing in terms of a trend is increased antitrust enforcement in this space, as well as legislation and litigation. And with that, I'm going to turn it over to Jen, who's going to share an image with you.
Thank you, Gretchen. Here is the image. As you may be able to tell, I asked a generative AI tool to create an image of algorithmic price fixing, or AI price fixing. And this is what it came up with. It's a little bit disturbing. Clearly, there's some humans and a machine, and I guess their brains are colluding together to commit some sort of antitrust violation. It's an interesting use of AI, the image tools, and I think that this is actually pretty good, because that's exactly what we're going to be talking about, is actual cases where plaintiffs have alleged that real humans have used AI tools to commit antitrust violations. So starting, as we usually do when we're talking about technology and antitrust, with some of the big firms. Let's talk about Alphabet, Amazon, and Microsoft. So back in January of this year, these firms got some inquiries from the FTC, I should say, asking them for more information about their investments and partnerships with AI startups, and in specific, Anthropic and OpenAI. And all of this was part of a study at the FTC about how AI is impacting competition in the technology industry. And we can kind of speculate that to some extent, the FTC is probably looking back on how these companies got the market power that they have to begin with, in digital advertising, in search, in shopping, and probably took some lessons from that and are taking a much closer look, as Gretchen mentioned earlier, at nascent acquisitions. And so they're seeing, okay, AI is this new field, and we're seeing Google and Microsoft and the big players acquiring quite a few companies in this space. And what do we need to do to make sure that this space remains competitive as some of the other areas like search and advertising maybe have become less competitive as these firms become so large over the years. So this new FTC probe is focusing on almost $20 billion in AI investments by these companies, obviously a huge amount of money, in a series of transactions. And they're concerned that these AI startups are now depending heavily, like many other startups have historically, on this old guard of dominant tech companies. And during the FTC Tech Summit on AI, they reiterated this position. They said it's central to their AI strategy in 2024 and the coming years, and talked about competition at the model layer, as they called it. Is talking about taking actions, deepen their understanding of competition among AI model developers, and ensuring that they do not become too dependent on the big tech firms, expressing some concern about the history there. So that's an interesting development at the regulatory level. Let's talk about class action litigation a little bit, my favorite topic. I do a lot of class action litigation in antitrust and privacy, and so this is a great intersection between antitrust and tech here for me. So the RealPage rental software antitrust litigation. This is a multi-district litigation. For litigators, you may be familiar. That means there were a lot of class actions filed in many different districts, and the judicial panel on multi-district litigation stepped in to centralize those for pretrial proceedings. And here the plaintiffs allege that defendants who are property managers and other users of rental software for multifamily development units engaged in a conspiracy to fix and inflate the prices of rental housing across the country. So there's quite a few defendants named here, and the plaintiffs are alleging that this is a conspiracy that took place nationwide. What makes it interesting is that the so-called hub of this hub and spoke conspiracy is this RealPage software, which is an AI tool that many of these defendants would use to set pricing for rental properties in their areas. And the key allegation here is that this software, and by the way, the software marketed itself, and this is one of its key differentiating points, use non-public data from competitors to provide users of the software with data and allow them allegedly to increase revenues by raising rents. And so this case is still pending. It's in the Middle District of Tennessee. In recent months, we have seen notices filed on the docket that some defendants are settling these cases. We don't know a lot of details about those settlements yet, but it does look like there have been some settlements here. And what the software did was it tracked not only a client's acceptance rates of certain proposed rents, but also the identity of the staff that requested deviations from price. And the plaintiffs alleged that the software essentially discouraged users from any temptation to override the pricing algorithm if the rents appear too aggressive. And it built upon this price setting software that was originally designed many years ago for Alaska Airlines, who interestingly was also accused by the DOJ of illegally facilitating information exchanges when it used that software back in the late 80s and early 90s. So very interesting case to follow here. A little bit more on the case here about how the plaintiffs allege that the vacancy rates rose as a result of the use of this software. And as I mentioned a little bit about the tracking of the acceptance rate and how the software facilitated alleged increase in prices among its users in various markets. So we also saw the FTC and DOJ filing statements of interest in that case, as well as some other algorithmic pricing antitrust cases. The statements of interest were filed in the RealPage case. They were also filed in this Duffy versus Yardy Systems case in Washington, as well as the Caesars Entertainment case that we'll talk about in a minute, which was filed in the District of New Jersey. As I mentioned, RealPage has to do with multifamily rental housing. The Yardy Systems case also has to do with rental prices. And the Caesars case, similar but a little bit different, has to do with pricing algorithms used by hotels to set hotel room prices. So all sort of similar in terms of market, but all pricing algorithms cases. And what the FTC and DOJ have done here is filed statement of interest and also briefs in support of oppositions to motions to dismiss the case. So they're asking the court not to dismiss these claims because they believe they have merit, and this is an important area for the courts to be focused on. So I mentioned the Gibson case. This one, again, has to do with vacancies in hotel rooms and software used to set the prices of hotel rooms. The plaintiffs allege again, a hub and spoke conspiracy. The hotel defendants are the rim of that hub and spoke, and the software itself is the hub, the software being sent in. This case, interestingly, though, was dismissed with prejudice at the motion to dismiss stage. The court found that there was no tacit agreement here and that there was no plausible allegation of a tacit agreement, because, among other things, the defendants didn't begin using the software around the same time. The defendants didn't exchange any non-public information with each other using the services. And I think that is a key distinction between this case and the RealPage case, where the software was using non-public information from competitors and sharing that information, thus creating the rim of the hub and spoke conspiracy. And also that the defendants didn't actually delegate their decision-making process to the software, and therefore this case was dismissed. So talking now about some legislative efforts, we've talked about the regulators and private enforcement. I will turn it back over to Gretchen.
Thanks, Jen. Yeah, lest we think only the courts are involved in this, you've got various senators that are trying to get into the act as well. What's interesting, and I wanted to mention, because Jen has talked about cases, all of which are still pending, and everything in that case, because they are still pending, changes by the day. As you might expect, the Gibson case that Jennifer just described, in the defendants in the various 3 cases that she talked about, where the DOJ and FTC have filed statements of interest, they've also, the defendants in those cases, have filed supplemental authority alerting the court to the Gibson decision. So it remains to be seen how these cases ultimately resolve, but clearly that Gibson decision is important. But both of the senators, one from Minnesota and one from Oregon, have introduced legislation. And the first one, really by Senator Klobuchar, is called Preventing Algorithmic Collusion Act. And it's exactly what, excuse me, exactly what you think it is. It is to prevent companies from using algorithms to set higher prices. Not prices, higher prices, although I suspect it's prices at all. And of course, what members of the Senate are saying is, look, their position is, I'll leave it at that. Their position is that automated price setting algorithms can create loopholes in the current antitrust laws. I'm not sure judges would agree with that, but certainly that's what both of these Senate bills are designed to address. So you've got 2 different senators proposing 2 different bills with respect on the same day, and it's all designed to deal with pricing algorithms. So a lot more, but it is clear that Congress, as with anything that we see in technology, it's very difficult for the laws to keep up with how fast the technology changes. And that's why a lot of this ultimately gets decided, at least in the first instance, in the courts. So with that, we are going to leave the subject matter of antitrust, and we are going to talk about AI washing. And Let us define it for you first. You may have seen this in the literature, you may have seen this in articles, but basically, well, what AI washing is exaggerating the capabilities of a product or a service that is being sold to make it appear that AI is being used in some form. And the whole purpose, it's really a marketing technique. And the goal is to make your product look more sophisticated, more innovative, more intelligent. And as with all products and services that we're seeing right now, if AI is being used at all, everyone is jumping on the bandwagon on this. The term itself derives from greenwashing, which we will talk about in a little bit, which is the exaggeration of how environmentally friendly your product or your service is. But I guess AI washing, at least based on everything that we've done, seems to have been coined on December 5th of 2023 by SEC Chairman Gary Gensler. And he's the one that basically took greenwashing and converted it into AI washing. I am sure that the FTC would like to claim ownership of that, since they're the ones that came out with greenwashing. But nevertheless, at least at the current state, Gensler is attributed with that term. But basically, you are seeing actually the SEC sort of in the forefront of this, as opposed to the FTC. Now, the FTC, and we're going to talk a little bit about what the FTC is saying about AI washing, but in terms of who's really taking the charge on AI washing so far, it has really been the SEC. So if we look at the federal landscape of AI washing, we're including on this slide various statements that are being issued, whether it's coming from the FTC or the president, or I think most of them are just really SEC, the president, and the FTC at this point in time, although we are going to talk, just because this is largely a California audience, we are going to talk about what's happening in San Francisco in this space. But in essence, everyone is sort of jumping on the bandwagon, and what their focus has been, and what we're focusing on here, really is the extent to which you are making statements about AI that are not true. That's all that AI washing is. And as with any false statement, if you are a publicly traded company, the SEC is much more likely to attack you for that. And we're going to talk a little bit about some of those attacks by the SEC that are relatively recent. By the same token, if you're making a statement and you're not public, the FTC very well may go after those statements. And they can do that. Obviously, the FTC has jurisdiction over you, whether you're public or private. And depending on the industry with the SEC, they may be able to go after you as well if you are a private company, because the SEC obviously governs more than just publicly traded companies. But what the FTC has said, and I think this bears mentioning, and they said it as early as February 27th, 2023, that AI as a term is ambiguous. And that's from a lawyer's perspective, that's scary in and of itself, because anytime the FTC tells you it is ambiguous, it means you are basically in a very gray area, and there's a lot of risk in that gray area. And if we turn to the next slide, there are some other notes here. in terms of where the SEC or the DOJ or the FTC are talking about AI washing. So as you can see, this started in February of 2023, and it is continuing as we speak in terms of workshops, statements, presentations. So I want to talk specifically about 3 SEC enforcement actions with respect to AI. So the Sewell case, some of you may be familiar with that case, but that case is an interesting case because it really isn't about AI at all. Now you'll see what we say about AI because what we're reporting on the slide is what the press release by the SEC had to say about it. That there were statements being made by Sewell and his company where they were misrepresenting the capabilities of what their fund was supposed to be able to do. But when you really look at the complaint that the SEC filed in the District of Delaware against, and it's a lengthy complaint, it's a 20-page complaint against Brian Sewell and Rockwell Capital Management. The crux of the whole complaint is about all of Brian Sewell's and Rockwell Capital Management's lies. Everything from Sewell misrepresenting the degrees that he had to his expertise, to the company's expertise. In essence, it is a pure fraud case because every statement that they made was false about everything. And as you might expect, the civil penalty applied to Sewell individually. The company itself had taken about $1.6 million from students in a class of Brian Sewell's, and the company was ordered to basically disgorge that money back. But the reason we're mentioning it is because the press release focuses really on AI and false statements on AI. So that comes out, that settlement comes out February of 24. And then a month later, have the SEC fining Delphia for making false claims about having developed AI capable of predicting company and industry trends. And at the same time, they're fining Global Predictions because this is great. It labeled itself as the first regulated AI financial advisor. As you might expect, the FTC didn't like that very much at all. And what both of these companies were essentially telling their investors was, we will get you better results because we are using AI and we're going to make better investment decisions for you. So naturally, the SEC was not happy about that. And as a result of it, it was fine. But the point of all of this is to say the SEC is absolutely paying attention to AI statements, and they're going to pay attention to it in the regulated fields that they control. So that's where the SEC has gone in the last few months. Now, I want to talk briefly about California. And I want to talk about it because in, I guess, March of this year, Reuters, there is a press release from the DOJ's top prosecutor in the Northern District of California, Ishmael Ramsey, who is announcing to all of California that he is taking on tech startups, and you can see it, fake it till you make it approach is no longer going to work. And he is claiming that his office is uniquely positioned to scrutinize tech startups that defraud investors in the startup. And that's obviously in the IPO stage. And so this has been, as we know, a lot of US attorneys decide what their pet project's going to be in the jurisdiction that they are. And this is going to be his project. He has only been the US attorney for about a year. And this is going to be his focus, and that's important because, as you can see from the second bullet, one of the reasons that startups, and for that matter, any company, is touting their AI capabilities, at least with respect to startups, the data shows that they will attract 15 to 50% more investments than those that don't mention AI. And so that's when it becomes important. So with that, I am going to turn it over now to Jen to talk about AI and greenwashing.
Yes, thank you, Gretchen. It's really interesting. So as Gretchen said, I'm going to talk about AI and greenwashing. And Gretchen previewed this a little bit. Greenwashing was actually the predecessor to AI washing, the first washing term that we heard from the FTC. And as you might be able to guess, it's a term that's given to companies making unsupported claims about how their product is environmentally friendly or something to that effect. So the SEC defined it as the act of exaggerating the extent to which products or services take into account environmental and sustainability factors. And as we all know, there is a huge focus on this recently. Every big company has a sustainability focus or initiative, it seems. And so it's easy to see how they can get carried away into potentially exaggerating these representations, usually for the purpose of marketing or helping sales. And greenwashing, interestingly, not just limited to explicit statements. It can also occur by a company's just use of quote unquote green packaging. And I don't necessarily mean packaging that is the color green, though often green packaging is the color green, but there can be other examples as well, including one that we see in the FTC's green guides, which I'll talk about in a minute. The FTC does provide guidelines around greenwashing, just as it does in antitrust provide, for example, merger guidelines. You can look to the green guides to see the FTC's positions on greenwashing going back as far as 1992. But one interesting example from those guides is a marketer's advertisement featuring a laser printer nestled in a bird's nest, balancing on a tree branch that's surrounded by a dense forest. And it reads, "Buy our printer, make a change." So this advertisement doesn't expressly claim that the printer is necessarily environmental or sustainable, but there's a clear implication there, and it's clear what they're trying to communicate through that packaging. And even something like that can be considered greenwashing if the marketer is not able to substantiate the claims. Of course, if the claims are true, then you are generally permitted to make them. I'll do all the qualifying, it depends sort of language, but greenwashing applies, of course, to false claims only. And let me click to our next slide. So what does the federal landscape look like around greenwashing today? The FTC, as I mentioned, issued the green guides first in 1992, so this is not anything new. They have been revised over the years 3 times, but most recently was 2012. And obviously, though, for many of us, 2012 feels like yesterday. It's been now 12 years, and the FTC has recognized it is time to update them again. And so at the end of 2022, they sought public comment on the current green guides. There was a comment period that ended in early 2023. And we're anticipating that the FTC will release the revised green guides at some point later this year. And so that will obviously be an important thing to take a look at and understand the FTC's new or updated thinking on greenwashing in order to avoid any issues there. And often private plaintiffs, which we'll talk about in a minute, do point to the green guides in complaints as sort of a guidepost of what is and is not considered greenwashing. So this isn't something that you'll only see referenced in FTC actions. Specifically, the FTC solicited comments on carbon offsets and climate change. We've seen quite a bit of this, especially since the last green guides came out, especially among airlines where you can even purchase carbon offsets now. I think that's going to be a big focus. Obviously, in the automobile industry, we're seeing quite a bit of that as well, but it's not limited to those two industries, of course. We're seeing it across travel and other industries as well. The term recyclable, we'll talk about that in one of the particular cases in a minute, but be careful when you're advertising that your product is recyclable. The FTC sought comments on whether it should change the threshold on recyclable claims. The term recycled content, they sought some comment on that as well, and particularly claims related to pre-consumer and post-industrial content and how those are understood by consumers as opposed to how those are actually implemented in practice. And then whether there's any need for new or additional guidance since the last green guides, including claims such as compostable, degradable, ozone-friendly, organic, and sustainable. So we will all be keeping an eye out for the new green guides and updating accordingly when those come out. Enforcement actions. In the last decade, there have been numerous FTC greenwashing enforcement actions aimed at mostly environmental marketing claims. They cover clothing, they cover bed sheets, they cover a lot of them personal care products and hygiene products. And companies have paid steep penalties in these cases. We've seen Kohl's, Walmart, as well as some smaller companies facing these actions from the FTC. Most recently was Kohl's facing a $1.7 million fine and Walmart with a $3 million fine in these actions. But we also see private lawsuits. These often follow on FTC investigations or can be independent from an FTC investigation. It's not difficult for the private plaintiff's bar. And as we all know, there's a very active private plaintiff's bar here in California to suss out false advertising cases, including greenwashing cases. So I litigate these all the time. You might have a company saying that their product is detoxifying, that it's natural, that it's organic. If you cannot substantiate those claims, expect to see, if not a federal investigation, a private class action lawsuit under the unfair competition law, the Consumer Legal Remedies Act, and a number of other laws that we have in place here in California. One source reporting more than 200 false advertising class action lawsuits are filed each year in recent years. And those are the ones that are actually filed. I can tell you, as someone who litigates in this space, that many, if not most of them, are never filed. Companies receive demand letters from plaintiffs' lawyers and negotiate settlements out of court. So that even sort of, I believe, understates how prevalent these are. It's an estimated threefold increase in recent years as opposed to a decade ago. And as we'll talk about in a minute, that could be in part due to the use of AI to find greenwashed products and prosecute these claims. In New York alone, New York has a very good consumer-friendly law on this as well, the GBL, General Business Law. Consumer class actions are estimated to have tripled between 2017 and 2020. And doesn't show any signs of slowing down, especially when the new green guides come out. If there's more guidance, we will probably see more litigation in that area. A few examples of private lawsuits of note. Smith versus Keurig Green Mountain resulted in a class action settlement of $10 million because the plaintiffs alleged that recyclable K-cups are actually not able to be recycled in many municipal recycling facilities. Also, Lee versus Canada Goose, which alleged that Canada Goose's commitment to ethical fur sourcing was misleading. That one was ultimately voluntarily dismissed on the basis of standing, but another one that was notable there. So now our intersection between AI and greenwashing. Can AI uncover greenwashing? There are many articles claiming that AI is the solution to uncovering and ending greenwashing. Many companies claim to use this technology as already. Consumer groups who are seeking to end greenwashing But of course, beware of the double-edged sword. If you're trying to end greenwashing by using AI, you could be AI washing. So we're seeing an intersection now between AI and greenwashing, and lots of folks writing about that. I think this is an emerging area. We haven't really seen, I have not uncovered any real world examples of this happening in practice, but there are certainly platforms that are claiming to be able to uncover greenwashing using AI, which means we could be seeing even more greenwashing and AI washing cases in the future. All right, so we reserved enough time to get to the best part, which is how do you, your clients, your company mitigate your risk around the use of AI? And I'll turn it back over to Gretchen to talk about that a little bit.
Yeah, so let's talk initially about maybe the antitrust component of AI risk. And if we think about mitigating AI risk, I think one of the things that we have seen, both Jennifer and I, is that a lot of times companies, the legal team just isn't involved. They aren't involved until it is too late. Agreements are signed, deals are struck, and no one has asked any questions about the company, the provider that is, in essence, you have an agreement with, and how, for example, algorithms are being used, how generative AI is being used. Or if you're developing, if you're on the development side, a lot of developers are not paying attention at all to the potential risk for antitrust violations, particularly if they are gathering data from competitors. And this is definitely, I don't think this is we haven't even seen the extent to which this is going to be enforced. It is just starting. But AI developers absolutely need to consider the antitrust risk at the design phase. And if you are reaching out and entering into an agreement with an AI developer, that is something where you need to ask questions. And a lot of times the lawyers know the legal component of it, but maybe they don't have the technical expertise. And that's an area where you need to make sure in your organization, do you have the right technical team involved? Or quite frankly, do you need to upgrade your IT team? And there are basic questions that can be asked of that technical team to sort of find out, how did you develop this model? What are the sources of your data? And learning some of the lingo is helpful in asking those questions. And if people are unwilling to essentially tell you how it works, what they're doing to protect data, that's like a major red flag. Anything that you will read out there in the literature will tell you that's a red flag. But a lot of times the questions aren't even asked because things happen so fast. I have seen with various clients press releases being issued regarding generative AI in lots of industries where the legal department isn't even aware it's going out, or for that matter, being asked to look at agreements well after the fact and try to basically backstop and fill in what's already happened. Jen, do you want to talk about the data issues and the risk of re-identification, particularly when we're talking about healthcare and other organizations like that?
Yeah, and I'm sure we're preaching to the choir in this audience, Gretchen, but this is another one that comes down to the communication between legal teams and other teams and understanding what is happening with your data. You may be told by a tech team, don't worry, all this data is anonymized, it's encrypted, but there can be risk of re-identification of data, which can cause antitrust issues as well as privacy issues. I mean, this is in most privacy litigation, The issue comes down to lack of communication between someone on the tech side and someone on the legal side, and understanding what is the website technology doing, where is the data going, how is it being used, can it be re-identified? These are all, obviously ways to mitigate risk, and we understand that those are challenging for in-house folks. But I think that especially when you talk about using AI, making advertising claims, that is really the key recommendation here.
And also, another recommendation in general, and we can see this on the next slide when we talk about AI washing and green guides, is literally just paying attention. Everyone is extremely busy, but the FTC, the SEC, and the DOJ are always issuing press releases. If you make a habit to look at those every once in a while, you will be is pretty up to date in terms of what your enforcers are doing. And as Jen and I will tell you, that's where litigation comes from. Class action, private litigation follows what your enforcers doing. So your enforcers are doing. So knowing what the FTC, the SEC, and the DOJ are doing is really important. And it is also true to some degree what your state AGs are doing. But a lot of this is federally related. We're talking primarily about federal related statutes and laws. But as Jen has already mentioned, a lot of states, California and New York, have very robust statutes, which is why when you talk about things like false advertising, unfair competition, you have a lot of those lawsuits being filed in jurisdictions that are plaintiff friendly in that space. And that's California, that's New York, that's Illinois. The green guides, we mentioned it because if you've never taken a look at them, they're very useful for understanding when you're getting into gray, dangerous areas. Why is that important? Because I do believe that the green guides are going to form the basis of what ultimately happens with AI washing, because the concepts are the same, and that's why we grouped this. That's why we really grouped this in a singular presentation, because I do think they are, as does Jen, very much related. Jen, do you want to hit on the proof area, the proof point, because you've mentioned that earlier in our presentation today about valid data and proof?
Yeah, so not only should you have a good coordination between legal and marketing department, or legal and your data people, you need to make sure that you actually have scientific proof about representations that you're making. So you may have a good faith basis to believe that your product or that you are using AI in a certain way, or that your product is sustainable or environmental. But the plaintiff's bar is not going to take your word for it. There needs to be scientific proof and benchmarking and things that you can point to if and when you do get that demand from a class action lawyer to substantiate your claims. So I think that's a very important point. Class action lawyers use private investigators to identify companies who are making these types of claims. They will probably, if they're not already, also use AI to identify potential targets. And so it's important that you have this proof before you make the claim, as opposed to trying to put it together after you've already received that demand letter. And that when it comes to greenwashing is in the form of actual scientific studies.
And I mentioned already AI capabilities and maintaining awareness of weaknesses, and that is often asking your internal people that are skilled in this arena, and making sure that as the technology changes, your organization is staying up to date on the technology, including evaluating the level of AI experience. One of the SEC cases that I talked about is really important because that was filed by the SEC based on a review of social media and a website. And I mention that because that's something that's relatively easy to do, which is look to see what your folks are saying in social media, because people tend to be a lot looser on social media than they do maybe on a website. But evaluate your social media postings by your organization, evaluate what's on your website. And if you have marketing people pushing out materials or going on pitches, evaluate that and raise questions on terms that they're using and whether or not there's any basis. Saying something is smart is different than it just being connected. And so you have to be really, really careful with some of those terms. Saying it's AI generated when it's not is literally false. And the penalties associated with a literally false statement are tremendous because the evidence that is required when something is misleading is a little bit different. So with that, I believe we are at our time. So I want to respect the fact that this was an hour, and I think you have been here for your hours, so you should get your CLE credit for this in California. I know that our law firm is also applying for credit. So if you are in a state that is not California and you're looking for CLE credit, you can reach out to either Jennifer or me. It will be in the PowerPoint, and we may be able to get you credit in other jurisdictions. I know right now we're definitely getting it in New York and Illinois at a minimum. So thanks everyone very much.
Yes. I see one question in the chat.
Oh, there is one. Okay.
I think it's just whether they can get the recording. I believe since the program was recorded that it will be posted on the ACC website with the slides. I don't know if someone from ACC can confirm that, but I know at least the slides are going to be posted. Any other questions?
Yes, it will be posted.
Thank you.
Okay, great. Thanks, everyone.
Thank you, everyone.
Bye.